Well, as you can see, I am still on vacation, but there's just way too much going on that I just have to talk to you about what happened today. So, we had another hearing today regarding the federal materials in the Karen Reed case that are about to get destroyed. And there's a lot of cases out there, including Miles King, including Brian Walsh, and a number of others that also have to do with Trooper Proctor and some of the other players that were involved in the Karen Reed investigation. And the feds investigated them, and there may be some very exculpatory information and evidence in those materials that will be very helpful to all these defendants. So there was a hearing a couple days ago, and then there was another hearing today. So this is it's a little technical, which is why we have to explain everything very simply so you can understand everything that's going on here. Okay. So now what happened here is that we all know, let's start from the beginning so we can set the stage. We all know that in the Karen Reed case, there was a federal investigation, and those federal materials were turned over to the Commonwealth and the Karen Reed defense team. But in order for them to get it, they had to enter into a protective order, a federal protective order, which means that it goes through a federal judge. The federal judge in this situation was Judge Casper. Judge Casper is a federal judge. They entered into this protective order, giving all the materials to the Commonwealth as well as to the defense and Karen Reed. And there were certain stipulations as part of the protective order. Now, we haven't seen this protective order because it's impounded. It's protected. We can't see even the order protecting everything, right? So everything's protected. But there's a lot of references to that order. So the Commonwealth, what the Commonwealth did is after the conclusion of the Karen Reed case, notified all the other defendants that have to do with Michael Proctor or some of the other players in the Karen Reed case, maybe Buchanan. So they filed a notice letting everybody know, okay, we have to now comply with this federal protective order, which requires us to turn the materials over and or destroy them. So let me show you just for an example, which is what everyone was talking about before. This is what was filed in the Brian Walsh case, but this is similar that's filed in a number of these cases. A lot of the cases where there are defendants, this is the type of thing that was filed. So let's just take a look at it. And it says, now comes the Commonwealth in the above captioned matter and respectfully provides notice that pursuant to an order of the United States District Court for the District of Massachusetts, Judge Casper, all confidential materials produced exclusively for the prosecution of Commonwealth versus Karen Reed will be destroyed or returned to the federal government on July 18th, 2025. Okay, so this is what was filed in the Brian Walsh case, and you see it's dated July 17th, 2025. Now, again, you may think that this is gamesmanship, letting everybody know a day before that you're going to return all of this information. But if you are following Massachusetts cases, this is not too much of a surprise. So you have them letting everybody know that, oh, by the way, tomorrow we are going to destroy all this information. And this may be very helpful for your case. And again, these are, even though these are materials that were turned over in the Karen Reed case, but they can still be helpful in all these other cases like Brian Walsh, Miles King, all the other cases that are involved. So this is the notice that they sent. Well, the attorneys in Brian Walsh case were on their game, and they said, hey, stop. So they immediately jumped into action and said, no, stop for a second. This is not just going to happen like this. And they started filing stuff to pause this and try to figure out what the situation is going to be. Now, the reason why this becomes a much more important issue for Brian Walsh and all of the other defendants is because what happens, and we spoke about this in previous videos, but let's just reiterate it again clearly. What happens when the federal government says you have to give us back the material? Remember, there's two different systems. There's the state system, there's the federal system, and these materials came from the federal system, and the federal government said, we will give it to you, but you have to follow our laws, our rules, and our rules are that you got to destroy them July 18th, whatever it is, 2025. And if you don't agree, then you're going to be in contempt of court. We can start initiate proceedings against you for not following a federal order, right? But here's the problem. Here's the conundrum. The conundrum is that the prosecutor now is bound, so to say, by that federal order, which requires the prosecutor to destroy certain materials. But let's say those materials are exculpatory for Brian Walsh. So yes, you're right. The prosecutor saw them in Karen Reed's case and was able to use them in Karen Reed's case. But what about Brian Walsh's case? What about Miles King's case? What about the prosecutor knows that there's exculpatory information in there, which can be very helpful, but And therefore, as a prosecutor under Rule 14 in Massachusetts state law, the prosecutor is required to turn all this stuff over, but she's also bound by this federal protective order. So she's kind of being pulled, the prosecutor is being pulled in different directions. The federal government says, you better destroy it or we're going to come after you with the might of the federal government. And on the other hand, you have the state rule that says, hey, if you know this exculpatory information for Brian Walsh, you got to give it over to him. You got to review it and you got to turn it over if it's in your possession, custody, or control. You can't do both. So what are you supposed to do in this case? And this is exactly why Brian Walsh's defense team filed a motion to dismiss based exactly on this issue, because they found this case called Liebman, which we went through in the previous video. And the Liebman 1, Liebman 2, they both basically say the same thing, that the prosecutor is required under Rule 14 to do whatever they need to do to turn over this information that they got from the federal government. If they don't do it, then the case has to get dismissed. So now these people, these defendants, Miles King, Brian Walsh, all these people, if this information actually gets destroyed, they have a very strong basis for a motion to dismiss, saying that was exculpatory information. You had Rule 14 obligations. You're right. You were stuck and you were bound by the federal protective order. That's fine with us. We don't care. But when it comes to the state action now, the state action must get dismissed. So this is exactly what's going on here. Okay, so that's just to kind of set the stage of what the state court is trying to figure out what to do with this situation. Okay, because they know if all these materials get destroyed, there's going to be a very strong basis for a motion to dismiss, not just in Brian Walsh's case, but all of these defendants' cases. And this is not exactly how you want all these cases to go away, by some procedural hiccup. So let's start now from the hearing that happened this past week, August 12th. So August 12th, as you know, there's a number of different attorneys on the hearing. Brian Walsh's attorney, Miles King's attorney, they're all there on the hearing, and some other attorneys also. And in that hearing, the judge was able, at least at that point, somehow they were able to pause this order. The order was the Judge Caspers' order to destroy everything or to turn it back over to the federal government was extended until August 17th, which is really August 18th, because August 17th is a Sunday. Okay, so they're racing against the clock at this point. So you're right that the first notice said July 18th, but somehow they must have gotten extended to August, maybe another month, to August 17th or August 18th. And now they're trying to figure out what to do. So the first hearing in August 12th, the way that the judge started off was telling the Commonwealth, telling the prosecutor, I told you guys to start working on this earlier. Why are you waiting? We're running up against the clock now. It's August 12th. The order by the federal judge, whom the federal judge could care less what's going on in the state court, right? So this federal judge has this protective order that you have to destroy it by August 17th, August 18th. And if you don't, you're going to get into a lot of trouble. And now it's August 12th, and we're racing against the clock. And I told you, prosecutor, that, and also defense, by the way, but really it's more the prosecutor's job here, to try to intervene into the federal case. So what does that mean? Okay, so that means simply, if you have a case going on, just a case between any two individuals, or between the government and a criminal defendant, but there is another interested party that wants to get involved and have his voice heard or her voice heard into this litigation or into this case. So you got this case going on, two parties are involved, and now somebody else wants to get in there and say, hey, I have an interest here. I need to be protected also. So you are able to make a motion with that court and say, and intervene. You want to intervene into the action and say, hey, I have an interest here. So what you find a lot of times is, for example, you have when you want live streams, you want trials to be live streamed. So the channels, the bigger channels, will intervene into the action and say, hey, judge, we're just intervening for this limited action, to a limited purpose, to allow us to live stream your channel, live stream the court proceedings, things like that. Here, the state prosecutor, what they want to do is what the judge was telling them to do was to intervene into the federal action. So remember, there's a federal court and there's the state court, two separate systems. So there is this federal case, which is under Judge Casper, who's a federal judge. It's an ongoing case. They have a case number with the federal court. And anybody who feels that they have an interest, can go ahead and motion the court, file a motion in that court and say, hey, we want to intervene with this action, let you know what's going on with us. We have an interest here. And the prosecutor definitely has an interest here. What's the interest? Well, they have an interest to, they have Rule 14 state obligations, which require them to turn over exculpatory information to other defendants. And therefore, they want to get the ability to have some relief from the federal protective order and to be able to review all these materials and see if anything is relevant for Brian Walsh or Miles King or any of these other defendants. And this is what the judge was telling the prosecutors to do for a while. He's saying, get going on this. Why are you waiting for the last minute? But as we are starting to see, that's exactly what happened in Massachusetts. They waited and they didn't do this motion to intervene until literally the last 11th hour. Okay, so that's the first little bit nugget of information that the judge started off with the hearing. Okay, then what else came out from that hearing on August 12th was that at that point of time, the U.S. Attorney's Office, so the U.S. Attorney is associated with the federal government, right? So the U.S. Attorney's Office said that we are not going to agree to grant an extension, meaning the U.S. Attorney's Office doesn't have the authority to grant any extensions because this is a judge. If you want to get an extension, you have to ask who? The judge. You can't just ask the U.S. Attorney's Office. U.S. Attorney's Office can say, yeah, you have our authority to have an extension, but guess what? It's not up to the U.S. Attorney's Office. But what they could do is that they can say, we will stipulate, we'll agree with your request to get an extension, or we will oppose it. And here the U.S. Attorney's Office was saying, we are going to oppose the prosecutor's request for an extension of this federal protective order, which would then, if they would get this extension, that would mean that they're not required to destroy this information, and they can still hold on to it and litigate this issue as much as necessary. So at that point in time, the U.S. Attorney's Office, again, this is August 12th, just a couple of days ago, at that hearing, the U.S. Attorney's Office said that we are not going to either seek an extension or stipulate an extension. And also, by the way, we feel that if you guys are able to, meaning if the prosecutor is able to somehow toll the order, so then that's fine with us. Okay, we're not going to seek an extension. Okay, so there's a difference here, right? The difference is, and again, it's very technical, but it's, if you're a law nerd, you'll love this stuff. So there's a difference between tolling and extending. Extending is if the federal protective order were now to extend till another 6 months. So then the order would be as if you were editing the order and putting into the order. Now it doesn't say August 18th anymore. It will say July of next year, something like that, right? That's extending an order. But then there's also tolling. Tolling is where we are going to pretend that everything's on pause. So we can't enforce the federal protective order because it's tolled. Everything is on pause. So if, let's say, it says you have 30 days to do something, we can just pause the clock. Just hit pause on the clock. And even though the rest of life is moving on, but as it relates to this federal protective order, it's on pause. That's what tolling means. Okay, so what the U.S. Attorney's Office said at this point on August 12th is that we are not going to oppose tolling this order. Now, Judge Caspers' concern is again, it's not up to you, U.S. Attorney. We don't care if you stipulate to the tolling of this order. If Judge Casper says, I'm not tolling that order, well, then it's not tolled. It's up to the judge. So he's very nervous about this. He's like, okay, we got to get the Judge Casper, on board here. And the Judge Casper may not care about what's going on at our level. What does Judge Casper care? They're busy with their federal docket and their docket of cases. Why should they care so much about us? So that's what happened. And then on top of that, August 12th was still where the U.S. Attorney's Office said that not only is our position that we're not going to extend the order, we don't agree to extend the order, or that we agree about the tolling, but we don't even think it's appropriate for you to intervene into this federal action. So this is like them telling the prosecutor and the defense attorney, by the way, stay in your own lane. Don't come into the federal government. You don't belong here. You don't belong in this federal case name and number. Don't even file the motion to intervene. Well, guess what? If you're an attorney, and again, it comes back to the same thing, you could tell the U.S. Attorney's Office, I don't care what you say. You're not the judge. You're just an attorney. So you think it's inappropriate for me to intervene? I don't care. If I feel that I have an interest and a good enough interest, and therefore I have a right to intervene, you guys, I don't care. I'm going to intervene. I'm going to file a motion. If you oppose it, go ahead and oppose it. And this sometimes happens. Sometimes there is a motion to intervene and there's an opposition filed saying that we don't think that this other party should be able to intervene into our lawsuit. Okay, this happens all the time. So this is essentially what happened. The U.S. Attorney's Office said, we don't think the prosecutor should even intervene at all. But what did happen is the prosecutor did intervene. So they did file this motion to intervene. Okay. So that is essentially how it was kind of left on August 12th. But what did also happen is that the judge did speak a little bit about this potential motion to dismiss, and he was asking the prosecutor, saying, hey, why don't you respond to what some of these allegations are? That if you have Rule 14 obligations, even if you are bound by this federal protective order, what does that have to do with Rule 14 obligations? Your state obligations to turn over exculpatory information. Even if you don't want to, because you're going to be in violation of a federal protective order, do you have any case that says that when you have a federal protective order, then you are relieved of your obligations, or you don't have to comply with your Rule 14 obligations? You need some sort of case. And the defense has a case that says that they do have to comply. And if they don't comply, then the case should get dismissed. So he basically kind of pointed to the prosecution and say, you guys better figure out a case here, because otherwise the defense may have a good point and we may have to dismiss all of these cases. So that's where it became a little bit comical, because they kept saying, well, Your Honor, we think that you have to abide by the federal protective order. And he says, okay, but what about your Rule 14 obligations? I understand that part, but what about your Rule 14 obligations? And they kept going a little bit in circles here, and they kept saying, well, there's a federal protective order. And he kept saying, yeah, but what does that have to do with your Rule 14 obligations? And at that point, they said, well, we need some more time to do some research. We have to respond to the motion to dismiss. Okay. So that was almost how it left off, except there was one more nugget of information that Attorney Tipton, who's representing Brian Walsh, added into the conversation. And that was that he said that it's very interesting. He finds it ironic that ADA McLaughlin is saying that she cannot even review the Karen Reed federal materials to see what is relevant for his case and Brian Walsh, when she actually did that in some other case. And again, I don't know the details, but this is what he's saying. He's saying that she did this in a different case where she did review some of the materials. She spoke to somebody else and they gave it over in a different case. So you can't do it in another case and then say that you can't do it in my case. So there was basically that was his argument right there. And he said, I'd like to get a response. And there was no response that I recall being, or give us some time to respond to that motion to dismiss. So I didn't really hear or remember any sort of good response to that question. But that is what happened at the last hearing, August 12th. Okay. So now what's supposed to happen at this hearing today, August 14th? Well, it's kind of like a status conference, because we know that Judge Caspers' order has to be, it expires essentially. The order requires you to destroy the information or return the information by August 17th or 18th. So we're really running up against the clock. So they had to have another hearing about this issue and see what happened as a result from more conversations. Did you speak to the U.S. Attorney's Office? Did you file a motion to intervene? Did you get an indication what Judge Casper is going to do? We kind of we want to know what's going on here, right? So again, today we had all the attorneys return to court that are involved with this issue. So it's not, a number of different defendants and their attorneys. And then that's what the hearing today was about. So Lisa Beatty is the handling these communications with the U.S. Attorney's Office. So she was the one talking for most of the hearing, and she's saying what happened. So she said that there was definitely significant progress from just a couple of days ago. So what happened? Well, the first thing is that she did file a motion in federal court seeking modifications, seeking to intervene and to modify the federal protective order. So this is them really, again, the prosecutor just intervening into the federal case and saying, Judge, can you please modify the federal protective order so that we can comply with our state Rule 14 obligations? That's essentially what their motion says. She didn't share the motion with anybody, and that's what she said. Actually, I think in the last hearing she said she's not going to share it. We didn't see this motion. You can't find it anywhere. So maybe she did share it, but it was private and she's not giving it over. Maybe her counsel said not to share it. But essentially, that's the picture that I got, that it was this motion saying, Judge Casper, please modify your federal protective order and allow us to comply with our Rule 14 obligations and review the materials and turn them over. So normally, she said, and this is again Lisa Beatty continuing, normally she said it takes 2 weeks for the other side to respond, U.S. Attorney's Office to respond, but they agreed about certain things. So the U.S. Attorney's Office did agree for the following. Number one, you have to understand that there were a number of federal materials that were turned over that are not subject to the federal protective order. So there's a number of Michael Proctor's texts that were already turned over. Okay, so that's number one. They're not subject to the federal protective order. So that's just number one. Number two is that there's two different categories of information that is covered by the federal protective order. Okay, so when you have a federal protective order, it doesn't cover everything. It covers a certain amount of materials. So what was, they split into two categories. Number one, there was the grand jury information, anything that was done in the grand jury, and also there was on the non-grand jury information. So the non-grand jury information, the non-grand jury materials that were turned over by the federal government in the Karen Read case, they are allowing again, this is a U.S. attorney's position. And again, they probably still have to get authority from Judge Casper on this, but they could review it and they could disclose anything that's non-grand jury related. So again, there's a grand jury, there's a federal grand jury in the Karen Read case, right? And all of that information, the transcripts from the testimony that was given in the federal grand jury, that's in a different category. If there are subpoenas that were issued in the grand jury, that's all part of the grand jury information. But then there's other information that the federal government investigated and retained, and they got this information and got these materials, and they turned it over in the Karen Read case that didn't have anything to do with the grand jury proceedings. Okay, so those are the two different categories. So the non-grand jury information, they are allowed to review and they are allowed to disclose to whichever defendant they feel it would be helpful for, and for their Rule 14 obligation. So anything that's exculpatory, anything that's relevant for their case, they are able to turn that over. The grand jury information. So what about the grand jury information? Well, the grand jury information, and again, this is apparently according to the U.S. attorney's understanding or what they have discussed with Lisa Beatty, and it doesn't seem like Judge Casper is aware of any of this. So again, it really comes down to Judge Casper, but this is what she's saying over from their agreement with the U.S. Attorney's Office, is that the grand jury information, the prosecutor is allowed to review, so they can review all the grand jury materials and transcripts and everything like that. And if they find something that's relevant or exculpatory, then they have one of two options. Either they could file a motion into the federal case and say, we need this information turned over, relieve us from the federal protective order so we can, or modify it so that we can turn it over to either Brian Walsh's attorney or Miles King or any other defendant, or they can make a TUI request. Okay, so very simple. The non-grand jury materials, no problem. Review it. Anything that you find, turn it over to the other side, to the defendants. The grand jury information, you could review it, and if you find anything that's you feel is relevant, either motion the federal court or seek a TUI request, which is also from the federal court saying, we need this information, right? Okay. Then they also agreed to having a 45-day status conference with Judge Casper. And again, the U.S. Attorney's Office agreed that everything that we're doing is going to toll the federal protective order. Okay. So that sounds like a very promising way forward, right? It's a great path. However, again, this is all subject to Judge Casper's approval. If Judge Casper says, no, you can't do any of this, I don't know what you're talking about. You guys can agree all you want. I'm the judge. I get to decide whether you're allowed to do this. And under the federal protective order, you cannot do this. And under the federal protective order, guess what? You've got to destroy all the materials by August 17th or 18th. It would really be 18th. So the Judge Casper, she could still do that. So again, they're kind of between this rock and a hard place where, yes, you can agree with everything that you want with the U.S. Attorney's Office, but ultimately, what's Judge Casper's opinion? Because that's the opinion that really counts. And they don't have any sort of information from Judge Casper. So if Judge Casper is on vacation now and comes back and reviews everything and says, hey, why isn't my federal protective order being listened to? Where's all these materials? Oh, you guys had some agreement with the U.S. Attorney's Office? I don't care. You still have to follow my rules. So that is really where they're trying to figure out, okay, what we're going to do here. So what they did is that they said, okay, you guys have this arrangement, you have this agreement, and maybe this is what your approach is going to be forward. But we are going to have another conference August 28th. And if anything happens August 17th or 18th or between that time where you hear anything from Judge Casper, and Judge Casper is going to take some action or maybe say there's no tolling, none of this tolls it. Because part of the argument here is that, well, if you file a motion regarding that federal protective order, that automatically will toll the order. Right now, they didn't cite any authority for that. They're just talking. And normally you would need some authority. As you know, on this channel, you always have to have some authority for any action that you want the judge to take or you as a lawyer to take. So you don't want to destroy the order because you feel that it was told because you filed the motion. Where's the authority for that? Maybe they put it in their motion. I don't know, because we didn't see the motion. But if the judge says, no, none of this is told, well, then they're going to be up a creek. So it seems like it's promising. It seems like Judge Casper's not going to just act like this and just come back and say, nah, you got to listen to me. No tolling, destroy all the materials, and all these criminal defendants in the state court. Too bad. Deal with it. Either you get a motion to dismiss and the case is dismissed and all these criminals are let loose without any trial, without anything, or Judge Casper will say, yeah, this all sounds pretty reasonable. Let's do it this way. Let's let everybody review it. If there's anything relevant, they'll turn it over, have other protective orders entered into regarding, let's say, the Brian Walsh case. Okay, it's limited to Brian Walsh, and they can't turn it over to the press or anything like that. So they could do just expand it, just modify it essentially. And that's most likely what Judge Casper is going to do in this case. Okay, so but then again, the Judge Krupp, is being very careful because he understands that the federal judge could potentially say, I don't care what you guys think and what you think I should do. I'm going to do what I want because it's my order. I can do what I want with it. And it's the federal government. You have a problem with it? Well, then you better be ready to fight the federal government about it. So Judge Krupp is very cognizant of that, and that's why he's being very careful with these proceedings. But that is essentially what happened this past week from August 12th to August 14th with these cases. And we will see, again, this really, the motion to dismiss that was filed by Brian Walsh is really riding. The best thing that can possibly happen for Brian Walsh is if the materials gets destroyed. That is really the best way that can happen, because if all the material gets destroyed, then he gets to file this motion to dismiss and maybe he goes free despite all the incriminating stuff that he did. So really the best thing for him is if Judge Krupp says, no, we're destroying all the materials, and too bad. And then the prosecutor's going to have to find some sort of case that contradicts Liebman. So that is where we are standing. That's where we're holding right now with this issue. So I hope that was clear now. Now you guys have a great understanding, hopefully simplified. And before we go, I do want to let everybody know that there may be something cooking in Brother Counsel Studios. There may be something very interesting cooking, and it may have to do with a lawyer that you know. So stay tuned, keep your ears peeled and your eyes open, and we may have some announcements to make pretty soon. Well, that's how I'll leave it for now. If you haven't yet, please subscribe and like, and we will see you next time.